Hey guys, happy Sunday. We are going to go live talking about brand protection and the importance of it, particularly in e-commerce, but in any business. And we're going to have a guest, just pin this, brand protection, pin. We're going to have our guest, Nina the lawyer. Never spoken to Nina before, but it'll be interesting to talk to her, get her perspective as well. Anybody who's got a business, particularly online business, but even the service industry, brand protection is absolutely critical. You cannot build and grow what you can't protect. So if you're serious about your brand, you need to start thinking about what moves you need to make in 2023, particularly in January and as soon as possible, to make sure you fill the gaps of protecting things that you have as assets in your business. And your number one asset is your brand, is your goodwill, is your name. And what can you do to protect that, protect it from competitors, and further develop your brand? So it should be a pretty interesting conversation. And, it strikes me when I talk to even seasoned entrepreneurs and they think, just merely filing a trademark is good enough. Well, filing your trademark is a good thing to do, but you also have to then police your trademark, right? So how do you do that? Particularly in today's world where copycats are very, very, very prevalent, and it's so easy to just fire up an Instagram handle and mimic what somebody else is doing, especially if they have success in their brand launch. So let's talk about, and I think I just saw Nina. Let's talk about how and why you should protect the brand and what are things that you can do to distinguish yourself from your competitors. So let's get Nina in here.
Hey, how are you?
Hey, Nina. I'm great. How are you? Nice to meet you.
Good. Nice to meet you
Perfect.
too.
And
Can
you
you
can
hear me
hear me all
okay?
right? Awesome. Awesome.
Yes.
I'm excited to have this conversation. I've never spoken to you before, so it's nice to do this all in live and have this discussion.
Yeah.
So I guess before we get started, tell us a little bit about you and your practice.
So I am a New York licensed lawyer. I've been licensed for, I don't even know, maybe 6, 7 years now. And most of that time I've focused solely on working with business owners. And those business owners have ranged from real estate developers when I used to work in Manhattan to small business owners that I work with now here, mostly as I work on Instagram, to market to brands that are maybe content creators or they have small businesses or they're agency owners or whatnot. And my primary focus is the contract side of things, but there's so much that you need in terms of IP protection and brand protection in your contracts, whether it's when you're collaborating with people, when you're hiring team members, when you're hiring, your clients, or you're hiring people as a contractor. So there's so much. People usually just think of trademarks and copyright. Those are really important, but I focus a lot on the contract side
It's
of things
funny,
as
just
well.
before you jumped on, my first words were people think it's enough to just file a trademark and say, yeah, I'm protected, I'm good to go. But especially in today's, in
Yeah.
today's world of launching up an Instagram handle very quickly and very easily, or a website and stealing your brand or building off of your goodwill, it's not the easiest or best solution on its own, at least, right?
Right. And I've even seen other lawyers who come on Instagram to market themselves. Traditionally, even people who have this knowledge, they don't maybe mean to, it's not intentional and malicious when they accidentally copy someone's brand, but people are used to operating offline where in your own community you would know if there was another store or another company with the same name. But then they come on Instagram and they don't see that, oh, that handle's taken with maybe someone has it spelled a little bit differently, which we know in trademark law does not really make a difference. It's the overall feeling that you get from the word. And I've even seen other lawyers have similar names to law firms that are on here that are trademarked. So it really can be an innocent mistake as well. But to your point, like you're riding off of then someone else's brand goodwill and someone else's brand reputation. So when someone goes to search for what they think is you and someone else has a similar name, that can really be damaging your business slowly without you even realizing
I
it.
agree. And one thing that we see a lot in my side of the world, so we do a little bit of the same work, but we have a little bit of a different niche, but we do a lot of litigation in the unfair competition world. So brands that are, or in online defamation. So comparative advertising, where one brand is just making false statements about another brand and using their mark in a way that is obviously detrimental to another business. So what I think people need to know what they should do and how they should enforce those rights, right? Which brings me full circle to having a mark or having a name is only so good unless you enforce it, right? Unless you do something about it. I don't know if you've ever dealt with, do you do litigation at all, or is it purely the transactional side that you help clients with?
Anymore. I used to work in litigation years ago, but I just do more of the preventative side.
And it's interesting because even your transactional side, it's kind of informed, right, by what would happen if a dispute arises, or how would I deal with this if this was in litigation, and what would a judge think, what would an opposing lawyer think of, right?
Yeah, that's all. But it's interesting to hear your perspective then, because you actually see it play out.
We see it play out, and it's really interesting in today's economy because, like you, most of our clients are web-based businesses. They're influencers, or they're doctors, medical professionals, other lawyers, and they come to us, and usually the first sort of step in the relationship with our firm usually is somebody saying something about me, I don't like it, or they're injuring my brand. Raees, what can you do about it? And we just start digging. We're like, okay, well, let's look at what protection you have. Let's look at, is it defamation? Is it fair advertising talk? Does it violate FCC rules? And we kind of do a complete analysis and say, all right, well, these are your options. And sometimes it's as easy as saying, unfortunately, you can't do anything because your competitor is speaking truthfully, or it's an opinion. They're not using your mark in a dilutive way, or they're not injuring your goodwill in any way. Sorry, there's nothing we can do. Other situations, it's much, much nastier, and maybe there's a lot of things we can do. Maybe it is defamatory, maybe it is diluting the mark, or maybe it's infringing the mark, right, in a very creative way. So we kind of look at everything, and then we decide, like, are we going to sue? Are we going to try to resolve this pre-litigation? And it's interesting, you said you're in New York, right? You're licensed in New York. Where are you physically?
Yeah. I'm in Mexico. I've been here
for
the last 2.5 years.
We'll have to come back to that because I'm interested to hear about that. But what's interesting about New York is we get a lot of inquiries from coastal areas, LA, New York. We're licensed in Arizona, but we get admitted in other states if there's litigation for like a one-time, pro hoc VJ, as they say. And so we've litigated in Northern District of New York, and every district has their own perspective on how aggressive enforcement can be or should be, right? And I think if we're going to you, if a client's going to you, what are some of the things, let me take a step back. So obviously, most people don't have contracts with competitors unless they're in a business relationship with competitors, right? So let's say somebody's getting into a deal with an influencer, and they're a brand. So we make chocolate, we want to launch our brand on Instagram, and we want to find all the foodie influencers, and a brand could come to you, right, and say, hey, document what we need to do to put the controls on this influencer. Is that something that you would handle?
Yeah, so if you mean like, okay, a foodie blogger wants to work with, you're saying if a brand wants to work with different influencers, how would they protect, their brand in that situation, their trade secrets, their marketing, everything? Well, you would definitely want to have a strong contract in that way, but you would also want, like, to your point, you would want to have your trademarks in terms of your slogans, your brand name, any logos, because then you don't want them to misappropriate it in any way that's not like within the sphere of or the scope of what they're working on. Similarly, when they hand you over content, you want to make sure that you have the copyright to use that, because without having that in the contract, the brand can't just use a piece of content that an influencer or someone creates just because it has their product in it. That does not give them the right to use that content on their page for commercial purposes. Things are a little bit tricky with like Instagram and TikTok, like reposting. You know, if you're reposting someone's story, they tag you in a story, yeah, you can put that on your story because Instagram has those features built in. And, you know, I don't know quite offhand, but I'm sure their terms and conditions have something in there about, you know, Instagram's right to the content, and it gives you like that little loophole. But if someone's posting something on their feed and they tag you in it, it's not the same as if someone's tagging you in your story and Instagram has that built-in feature for you to share it. If you want to kind of take that content and make it more permanent and have a presence on your page or put it on your website or use it in an ad, brands cannot do that without having the explicit permission from the content creator. And that usually comes in forms of the contract. So that's a big misstep that I see with people all the time. And I see it a lot of the times with these smaller brands that maybe a foodie blogger comes to, you know, I'm in Mexico, right? People will come over and they'll be big food bloggers from New York or LA or Vancouver, and they'll take videos and photos of cool things that they see here. And I'll have my friends, I see my friends, they just like screen record and repost it on their page. And I'm like, you cannot do that. They get paid a lot of money, yet they're doing you a favor by posting a video of you, right? Like it's content for them. They're kind of doing it for fun. You can't just take it and repost it and then like plaster on about how this person really enjoyed your brand without having some kind of conversation and permission from them, because it's violating their copyright, especially if they are using, you know, professional editing software and professional camera equipment and things that they've invested funds in for their business to grow. So I hope that kind of answers your question somewhat. For brands, it's really more important. I would say, like, I kind of caution brands to think more of protecting the relationship and their right to use the content between the brand and the creator versus like, oh, how can you protect yourself against the creator like using your IP? It's kind of the other way around. Like you want to make sure that they're not coming back at you later on. So you have to, that's the most thing that you need protection for, the most important thing you need protection for, not really them using your logo or your brand.
No, it's well said. It's like, depending on obviously who you represent, if you represent the brand, then like in many cases, we have a few brand clients who are launching products online, and it's, listen, you need to make sure that if there's any joint creatives, that you either have an understanding that you're both equally going to own it as co-inventors, co-creators rather, or you have exclusive rights to it, right, to content that you jointly create, but you're paying them for that, right? Because like you said, influencers are in the business of creating content, and they don't want to be gypped either. And unless you stipulate to it in writing, particularly under the Copyright Act, it's very clear that if you hire somebody to do work and they're not your employee, you don't own it unless you stipulate to it and you assign it in writing. And I think in today's economy, it's really, people are really sloppy with it, right? It's fast and loose, and I get these calls all the time. Well, hey, I asked them to make this, you know, video for me, and they sent me like a DMCA notice, or they asked me to take it down. We're like, well, duh, because you didn't agree in writing as to the allocation of rights, exclusivity, whether you could even use it. It's not yours. You have to agree that it is yours. In the absence of an agreement, it's the creator who owns it, like you said. And it's interesting. Do you ever see people who have multiple social channels, maybe TikTok, Instagram, and then the brand may take an influencer's video and then use it on their YouTube? I've seen that recently.
I haven't seen that. I do know, I have to say, out of all the creators or all the platforms, the people on YouTube tend to be the most cautious and the most knowledgeable about copyright laws, because I feel like it's easiest to make a claim and YouTube will take it seriously when they take down notice, and you have to like make sure you're within fair use and all of the things that you were kind of mentioning at the start of this live. So I haven't seen exactly what you're saying. The only times I've seen it is that if a YouTuber is having like they're doing a video essay or a podcast or something, and they'll take a clip and they'll make sure to, the YouTubers I follow at least, like they usually are really on it, because as they scale to a certain point and as their channel grows, they've learned from negative experience where someone has given them a takedown notice or they've gotten serious warnings from YouTube. So that is what I've seen. I don't work with too many YouTubers at the moment because I know like most of the sloppiness, most of my clients tend to be people who are on TikTok or Instagram and like doing it a little bit more of a sloppy way. So I'd love to hear your experience with what you're talking about with relating to about YouTube.
Because I think TikTok probably made this issue, it compounded this issue from a legal standpoint, but TikTok, as many people know, or many people don't know, sometimes even lawyers don't understand, is they have commercial use music and they have non-commercial. So if you run ads on TikTok, for example, or if you have a brand, the little audio bites that you can get, the stock audio, is not for use for commercial purposes. And I've had people get their whole, your TikTok ad campaign gets completely slashed. Like, well, what happened? I'm like, well, I know you're a creator and I know you're smart, you know how to use TikTok. Did you actually read the terms or do any research on what your rights are as to the music in your content? Because you can't use those unless you use the license. There's a separate bank of audio. So in a similar way, I think people are doing this. Instagram, it's not policed as much, I feel like, but same principle applies. People think in the YouTube world, I just had this discussion a little while ago, hey, can I use 20 seconds of this Dr. Dre song as an intro to my YouTube video or to my podcast interview, right? Can I use 10 seconds as a lead-in? And the answer is no. It's still infringement, okay? There's an argument as to whether it's de minimis, whether it's clearly commercial use. There's questions about how much it impacted, the license holder and all that. But from a pure legal standpoint, right, it is infringement. And if the creator or the licensor wanted to give you help, they would just do a demand or a DMCA. And like you said, YouTube is very, very responsive to those. So now you lost your content because of 10 seconds, 20 seconds, or in some cases longer audio. So I'm seeing some of that. I'm seeing creators being a little sloppy because of the ease with which they can create content on TikTok and Instagram, and just getting sloppy and using other people's stuff.
I think that's something also that I see a lot, and people think, oh, well, I'm never going to get caught. And I see that also thing, like, and I've even used like photos I found on Pinterest on my Instagram, but I always try to edit them so that it's like part of the creative process and fair use. But even I'm like, like this is kind of like the laws are very still evolving, and also people's knowledge and is limited, and also the enforcement on the side of the creators is also minimal. I do think that as we grow with blockchain technology, and I think in the next 5 years, 10 years, the space is going to look vastly different, and there will be automatic, I think, algorithms and AI that will be able to pick up on this. I think that there will, with blockchain technology, be technology inside of the platforms that we use, where if I use a song by Dr. Dre or whatever for my YouTube intro, I do believe, YouTube kind of has this a little bit already, where they'll be able to pick up on it and instantly tell you, like, nope, this belongs to this creator, you're not allowed to use this. So I think that a lot of people choose the ignorance is bliss route, but I think that is something where it's limited to this period of limbo that we're in now. And I think the next 5 years, 10 years, the technology and the social platforms that we're using are going to grow, where it's going to automatically like rule. I even posted a video on TikTok recently where I took a video, I went to Tulum and I took a video of the Instagram famous Tulum jungle gym, the outdoor gym. It's like rocks and wood and whatever. Somehow, like 4 months later, TikTok took down my video for copyright infringement. It's my video. The metadata on my phone shows it's my video. I was confused, but it wasn't even an important thing for me to fight. So I was just like, whatever. I didn't use any audio that wasn't, being popularly used on TikTok, right? And if it's the audio that's a problem, they'll remove the audio. So I was very confused, but I thought, okay, so they're already having they're already testing these programs and these algorithms to be able to figure out like what's infringement or not. Maybe my video was very similar to another view, another perspective, because everybody goes in and films this gym in the same way when they're walking. But to me, that showed me like, wow, the importance of blockchain technology. Like, how dumb is this app that they can't tell that the phone that I'm posting this from is the same phone that I am,
Right.
recording this from. And I think that that's something that is going to
I
change
wonder,
in the next 5 years.
yeah,
So
I wonder if it was, did you accidentally capture live music in the video that maybe somebody had a problem with? Or
I don't think they were playing music. No, I think it was just like I filmed the video on my Instagram and I used a filter. I downloaded it off of Instagram and I reposted it to TikTok. I'm thinking like maybe that's something, but I don't see how it would be anything someone would have reported. For me, it was something where I feel like it was error on the back end. I don't really fully know how TikTok, polices or does that, but to me I took it as, from my experience, like a wake-up call as to them testing these different programs to be able to pick up on these things without necessarily needing like a report or something like that, where they're testing like the technology to be able to recognize this themselves. And I think that will get even stronger, and it's very important and necessary on a platform like TikTok. It's necessary on a platform like Instagram Reels. So I applaud them, but I think that as we grow and blockchain technology becomes even more embedded into the things that we use every day, these problems are going to become a little bit easier for the creator to deal with, because you'll know you have a record of like, hey, that was mine and I could prove it, and things maybe some enforcement and maintenance of a trademark or copyright might become a little bit more automatic. But as like a novice creator, you are going to really have to step up your game and your knowledge and your awareness of copyright laws, of fair use and takedown and all that stuff too. So it's going to be even more important for creators to be knowledgeable and act within a proper
agreed. Well said. Let's jump back to contract drafting and language that you would use, whether you represent a brand or a creator, to protect the brand, protect the goodwill. And one of the things that I like to use, and you probably have these provisions in your contract, is the ability to get an injunction if somebody on the other end of this contract is doing something in violation of the terms. And specifically, the most common violation, right, is they're associating the product or the brand with something that was not contemplated or was not agreed upon, or in fact, frankly, against the terms. Like maybe the logo is associated with something that was you considered as a company immoral, or you considered competitive and maybe even diluting to your brand, right? So one of the best remedies, in my opinion, and I'm curious to hear your thoughts on how you do this, one of the best remedies is to get an injunction, a temporary one, because you don't always know if the signatory to your contract has the money to pay damages. So do you want to go through this whole hassle of suing to get a remedy you may not even be able to get? What do you think about that?
So I think a lot of people don't even have the awareness of what an injunction is. So for those of you who might not even know, a lot of people think that when you sue someone, you could just make someone stop doing something or start doing something, but that's a special kind of remedy from the courts called an injunction. A lot of people, like, they don't understand that you can have the money side of your damages and you can have injunctive relief. But there's a lot of limits, as you know, from the litigation standpoint, there's a lot of limits on your right to tell someone you need to stop doing this or you need to start doing this. And I think different jurisdictions, from what I recall, have different kinds of like interpretations and different kind of rules. But in order for you to kind of have like this peace of mind that it is an option for you, it should be in your contract. How that's interpreted by the different courts, you would know more than I would. But I do think also making it really clear that, like I always say to people when we're drafting their contracts, you want it to be written in very plain English because you want the other person to be able to read it and understand it so that they don't cross your boundaries. So when things are, you know, yes, you want to have the right to injunctive relief in there, but it needs to be spelled out in a way where even if they're just skimming it, they understand what the consequences are. So I always try to break down the contracts into different, you know, obviously different sections. And then I'll also have Schedule A's, Schedule B's, attachments at the end of the contract that are kind of incorporated in, and for in layman's terms. And one thing that you can do is you can have like a penalties page, right? Maybe that will make it stand out for people to really understand what the penalties are. So for example, you might have things in there about like injunctive relief for the things that you just talked about, but you might even also have things like, okay, late fees. Sorry, there's like ants crawling all over me because I was eating peanut butter toast right before this, and it's ant season in Mexico, and ants. So I'm just like, if you see me going like this, there's ants everywhere. So one thing you might say is like, okay, if you don't do this, not only will you get this late fee, but then also maybe then at the very end you can include a clause about injunctive relief, but also have the verbal conversation explaining that to the other side, because you, like you said, you don't want to go through the whole enforcement process and not really even get the chance to win in the ways that you said you do. But people also look at the dollar signs. So I also have like certain penalties in there in monetary terms as well, because again, like you want the other side to understand what you're talking about. And a lot of times they might not really understand what injunctive relief is, but they'll recognize like, oh, if I don't do this, there's this much in a fine, and they'll kind of like be receptive to that as well. So that's the strategy on our end when we're drafting contracts. But again, like a lot of people don't even want to go through the process of litigation. So I'm curious to know, in your experience, if you guys do arbitration or any kind of other recommendations that you have for alternative dispute resolution, because to your point, like injunctive relief is something that courts might not always grant. In your experience, is it something that they can also resolve in arbitration or something
question.
Like that?
So in the contracts where we represent a creator, actually we'll start with the inverse because it's easier. If we represent a brand, and the brand is entering into many contracts, we basically explain, listen, you don't want to be tied up in litigation if everybody, worst case scenario, defaults on these contracts. So what is the quick and dirty way to resolve it? So we create, my practice at my firm is we create sort of a 3-tier dispute resolution system. And this is particularly important in these IP protection brand deals scenarios. So the first tier is, we say, look, you on the other side, or me, if I have a problem with something you did under the contract or didn't do, I have to give you notice, and then we have to work together in good faith to try to resolve it, right? And I'll put a reasonable time period, 20 days. I don't want it to go too far past that. From then, if we can't resolve it, it goes to mediation. We can appoint a third-party neutral mediator. If we're dealing with cross-jurisdictional issues, like somebody's in New York contracting with somebody in Scottsdale, then we'll maybe agree to a remote mediation where both sides can nominate a mediator, and the mediator picks a third final mediator. And then the third sort of tier is going to be arbitration or litigation in court. And that decision really, there's a lot of considerations to it, and it's difficult because with arbitration, for the layperson, arbitration it can be cheaper, it can be faster, it can also be the exact opposite. And so it depends on what forum you're in, what rules apply. But what's nice about arbitration is if you're dealing with trade secrets or non-registered IP, Arbitration's private. There's no public filing. So I like that. What I don't like as a litigator is the inability to appeal an arbitration ruling. Like there's a very narrow window within which you have to appeal, not from the time standpoint, but rather the basis for appealing an arbitration ruling is very, very narrow. It's like miscalculations by the arbiter, fraud by a party. So those are some considerations. But to your point about immediate relief, I always say, notwithstanding these three things, if I have an emergency and anything relating to IP being misappropriated, right, or infringed is an emergency issue, we want the ability to get an injunction ASAP. And so I will put in my contracts that, the company reserves the right to seek an immediate injunction, and very, very important to put this, in my opinion, without having to obtain a bond to secure the injunction. And we get to do that in our forum. And I put a forum clause. And the reason is because if you need a fast resolution, right, to stopping the infringement, stopping the misappropriation or abuse of the mark, you're not going to want to go through those three steps, right? You're not going to want to try to mediate first for 20 days and arbitration. So I try to give an immediate emergency opportunity to resolve something. And actually, in most cases, judges love that. They like that there's an immediate injunctive because, not to get nerdy with how you win an injunction, but you basically have to prove you're right very quickly and upfront. You have to tell the judge, Your Honor, we're entitled to relief on this. Here are the merits to our argument. It's not protected speech, et cetera, et cetera, et cetera. We're most likely to win in our favor, and judges will grant those. A temporary injunction, right? Not a permanent one, but a temporary one. So that's a long-winded way of saying I usually do three-tier system of resolution, always reserve the right for an immediate injunction, and always waive the bond requirement in writing so that my client doesn't have to fork up a bond if they're wrong, which can be very expensive. So I hope that answers your question.
Yeah, no, that's great. That's great feedback as well for, it's very interesting. I feel like there's a lot of people who think that they can draft their own contracts, right? Or
yeah.
They can pull something from the internet and do this by them. And it's these kinds of intricate nuances that come from the litigation standpoint and like your experience of seeing how things play out, these real life examples that people don't realize is what you pay a lawyer for, because someone thinks from their perspective, from their own business experience, and they don't see what we see, which is the cumulative experience of all of our clients and the conversations we have with our colleagues like these, where everything is feedback and everything is another example for you to put in. I do see people then saying, I just want a simple contract. I just want it to be no more than 5 pages. But then they want all of these different protections. And to put in something like this is like an extra few lines that they don't realize might actually come into play. So these things are very important conversations to have, and they just remind me of a little bit of pushback to my clients who they think that they can there's a time and a place for a template, right? I sell templates, but there's also a time and a place where if the stakes are really high and you're about to embark on a brand new venture, you're scaling your company, you have big visions for it. If you think that it's worth you investing the next 5 years of your life into this business venture, you need to invest, set aside 5 figures to invest in good legal fees where you can have your trademarks filed, your copyrights, if it's anything like that, or patents, in certain situations, and good contracts, good customized contracts to work with different brands, different creators and whatnot. So everything is always evolving, and they're great tips for me to include in my next brand deal contract.
Real quickly, I wanted to touch on this. You just triggered a thought, which was, sometimes filing a mark is not it's not an onerous process, right? There are a lot of online services, even LegalZoom, I think, where you can go and you can file a mark. The problem is,
Right.
if people don't get the analysis or the advice of a lawyer as to the strength of the mark, or what are common law rights versus registered rights. And I find myself explaining this to clients all the time. They're like, hey, I filed my mark first, or I'm going to file this mark. And I'm thinking, dude, there's a good chance that somebody could dispute when you publish, or even after the fact, dispute your registration and make that fall into the generic category or cause you to lose some level of protection. And so it's always important, I think, to talk to people like you and I to say, hey, even if you don't want to pay a lawyer to file, like maybe you should at least consult with the lawyer to say, what do you think of the strength of my mark? Or what are some of the pitfalls of trying to register this? And my favorite one is somebody who sees somebody using a brand name and they're like, well, I thought of it first, even though they don't have their business website, Instagram, they're not selling anything yet. Like, well, oh, I came up with that name. And they check, oh, it's not registered. I'm going to register. Well, unfortunately for you, common law rights apply to that use in commerce as long as it's a bona fide use. So they actually get a priority within their jurisdiction of where the brand is known, right? And this happens to big brands. One of the big cases on this was Burger King. You probably know, where they went into a territory and they saw, like, I don't even remember what town it was, but they saw a small mom and pop named Burger King, and they're like, we are the Burger King. You can't use our stuff. They litigated it, and the small mom and pop won and ultimately licensed their name to Burger King. So stuff like that, like you said, there are nuances, and it's not just push of a button kind of thing, right?
Yeah. So I think it's very important people set aside this time if you know that you're growing your business, or you want, again, like if you're willing to invest the next 5 years into a business venture, you want to make sure that it's 5 years minimum, right? Into a business venture. You want to make sure that you don't have any of these unforeseen things on the legal end. Financial, it's a whole nother conversation that can come back to bite you, because if one of these legal things comes up, it can really take away all of your time and all of your energy and a lot of your money, and it could make or break your business. And for those of you who think, oh, well, I don't care about my business in 5 years, or you don't have a 5-year vision for your business, then you shouldn't be going into business. Right? So that's like, I do see that a lot in the online space, and I see a lot of short-sightedness. People just want this get rich quick, fast money. A lot of people going into brand deals or going into content creation or going into online business, they think that way. They don't have a 5-year vision for themselves. So I encourage people to create a 5-year vision for yourself, even if technology is always changing and things are changing. Have some kind of intention, and then meet with a lawyer to, you don't need, there's a reason I sell contract templates. You don't need a custom contract for every single thing you do in your business. You don't need a custom NDA if you're just like hiring a, VA to work a couple hours for you a week. But with these big things, like you're getting a huge opportunity, or you're about to start taking on higher ticket clients, or you're a content creator and you want to work with brands, or vice versa. You're a brand that wants to start allowing content creators to market for you. Those are the stages in your business where you need to think and make your own business judgment decisions as to whether this is something where the consequences are great enough, where if you mess it up, then it's going to take away a lot of your time and energy. So don't take the risk. Go to a lawyer, meet with them. You don't need them to do every single thing for you, right? Like you said. But to have a lawyer that you can at least consult and ask questions is invaluable at whatever stage of your business that you're at. So I think that's a great place to end on that note, at least, in terms of like just making sure people understand, like, lawyers are not here to nickel and dime you and tell you not to do something. They're really here to just walk you through the process and help you weigh the cost benefit analysis of what's going to cost more money now versus what might cost more money later based on the level of risk that we can see from the information that we have.
It's all a question of the amount of risk and how much you need to mitigate that risk and what it's worth, right? Like you said. So great. Well, this was really, really fun. It was great to meet you and talk to you, and we should probably do this again sometime. I'm curious to hear how you ended up in Mexico. I'm sure that's a whole nother conversation and a whole different live discussion. So we'll have to do this again at some point.
Yeah, absolutely. And I have a podcast too, and one of my goals is to bring more lawyers on and hear more of their stories as well. So I will have my team reach out to you about that as well. We can have the conversation for those people who want like more of an audio experience. But yeah, it was great chatting with you. Hope you enjoy the rest of your weekend. And now it's great to know someone who I can refer people to when things do get sticky and into that like dispute resolution situation. Because I like to be on the preventative side of things.
I don't blame you for that at all. But I would love to work with you and your clients if the need arises. So we'll definitely keep our eyes and ears open. But how do we find your podcast? Is it linked in your profile? Okay.
Not at the moment. It's called the Non-Negotiable Success Show. And you can find it on Apple or Spotify. And yeah, I'm making a comeback soon. So you guys can connect with me here on Instagram, and you'll see more announcements about the podcast when it comes up. And yeah, again, hope to have you on there and learn more about the dispute resolution side of things too, because that just helps me as well when I'm doing the preventative. It's like a mutually beneficial relationship, a transactional and a litigation attorney, right? We make our job easier. Make our job easier.
Absolutely. Well, this is great. Nina, thanks for taking time out on a Sunday to hop on, and we'll do this again soon. Awesome.
All right, thank you.
Bye.
Thank you.